who ought to be on the Zoom part of the call and who can connect via YouTube. Feed going, and then we'll figure out who. There's the YouTube. All right, Mr. Roberts is here. I see him, and he represents plaintiff Willowwood, 1012 Willowwood. Is Ms. Lawson on the call?
I'm here.
Hey, Ms. Lawson. Is Mr. Holloway? I have some hard to identify folks in the waiting room. Is Mr. Lawson going to be joining us?
Mr. Holloway is on the call.
Okay, Mr. Holloway, is he, does his phone number end in 7841?
Yes.
Here he comes.
Hello?
Hey, is that Mr. Holloway?
Yes, sir.
All right, are you in the same room with Ms. Lawson? You may need to be somewhere else.
I'm actually just now coming in the house, so I'll be able to make it.
All right, so I just muted Mr. Holloway. We can unmute him if he's going to be in a different spot than Ms. Lawson, but we get some crazy echo effect if there are two people in the same space who have logged in separately. Mr. Roberts, there are 3 people in the waiting room. Someone identified only as Lisa. There's a Dolores Saunders. I'm familiar with that name, having read some of the documents. And then there's an iPhone. I mistakenly let that person in, some guy sitting in his car. Those folks can all participate via YouTube unless someone's planning on having one of them testify.
Lisa Lee is my paralegal.
Okay. Here she comes. So I'll leave the other 2 folks in the waiting room. If they're associated with one side or the other, you can let them know that there's a YouTube feed where they can see and hear everything that's going on. But I typically don't include in the actual Zoom call folks who aren't going to be engaging in the discussion. All right, and Ms. Lawson, we lost Mr. Holloway. Is he going to be sitting with you or
yes.
what?
He's sitting right here next to me.
Okay, great. So the screen tile that says Galaxy A21 will be Ms. Lawson and Mr. Holloway. And if Mr. Holloway is going to be saying something, if he can be on the screen, that would be great. But it's fine having you on the screen, Ms. Lawson, until we're hearing from Mr. Holloway. All right, well, let's get started. This is 2020 CV 338327. I'm Judge McBurney. This is the first time I've ever handled a petition for ejection of intruders. And I must say, I'm surprised that Mr. Roberts is on the side of the V that he is. He's normally that knight fighting on behalf of those who are being evicted. And here he's the evictor. So I don't know if he's turned over a new leaf or there's more money on this side of the V, but it is most unusual to have Mr. Roberts not protecting the occupants, but in fact trying to kick the occupants out. And he's using a technique that, as I said, is new to me, but thanks to Ms. Niles, my law clerk, I have been able to do a little homework on how these petitions for ejection work and don't work. And so we'll have a conversation about it. As I understand it, the property involved, which is 1012 Willowwood Lane, is owned by an LLC. That's the plaintiff in this situation. And the LLC's name is the property address. That LLC was originally created by Dexter Williams, whose name comes up in a confusing and borderline suspicious number of ways throughout the various transactions. At some point, Mr. Williams transferred the LLC to a gentleman who lives in New York. Mr. Fleischer, I think is the name. But regardless, it's not Mr. Williams. It's Friedman, Ari Friedman. He is now the sole member manager of 1012 Willowwood LLC, which is the owner of the property. That was all back in 2017 or so. Fast forward to late 2019, as I'm understanding it from reading the documents, and we'll have a discussion about this, Ms. Lawson and Mr. Holloway begin to occupy the property pursuant to what they say is a lease. And we can look at some of these documents and work through it. But in connection with the lease, we had a Ms. Saunders, who is sitting in the waiting room, who represented herself to be married to Dexter Williams. There's that name again. And Ms. Lawson and Mr. Holloway understood that they were in good faith occupying the property by paying rent. And I'm going to learn a little bit more about to whom they paid the rent, et cetera. But they believed that they were properly occupying the property pursuant to a lease. And lo and behold, they are served with paperwork that is telling them they're going to be ejected because they are, quote, intruders, unquote, which it sounds like surprised them because they don't fit the classic intruder. They're not squatters. They didn't break in. It was not an abandoned house that they were occupying, anything like that. It sounds like they believe they have paperwork that they executed that gave them right to be in the property. And now someone they've never heard of, Mr. Friedman, is trying to eject them. So we're going to talk about this today. I suspect we won't resolve it today, but I'd like to hear from both sides and we can figure out how best to proceed. So Mr. Roberts, I'll start with you as counsel for the ejector. Let me know why we're here and why you think that the counter affidavits have not created a question of good faith on both sides. There's no question Mr. Friedman is through the LLC, the person who owns the property. But as I'm understanding this ejectment set of statutes, if there is a showing of good faith on the other side, then this isn't the right vehicle. And if it's non-payment of rent, you know what to do. You get in front of a magistrate. And it sounds like someone on several occasions, and here's Dexter Williams again, tried to dispossess Ms. Lawson and Mr. Holloway, and then just decided it wasn't worth his while to show up in front of the magistrate, and that got dismissed. So, Mr. Roberts, your turn.
Well, there's no lease, there's been no money paid, and they did not receive permission to be in the property, nor did they have access or received a key.
How'd they get in?
No one knows, just showed up one day and they were there.
You showed up one day?
No, the person that maintains the house, cleans the house, and checks on it periodically.
Who's that?
That's an associate of Dolores Sanders. I don't have her name right off. I think,
but someone associated with Ms. Saunders.
Yes, and I'm sorry, Ari Friedman.
So Mr. Friedman came down from New York, Long Island, to check on this empty house in Atlanta?
He has someone do it, and it was furnished. He has someone do that for him.
Okay.
Periodically. All the utilities were on, it's furnished, and he has someone that lives in Atlanta check on the house periodically.
If you know, what's the point of paying a mortgage on a property for 3 years that is furnished and heated and cooled and unoccupied?
He's trying to sell the property.
Okay. So this is an investment property for him, but not in the form of income generating, i.e. leasing it. It would be, I acquired it from Mr. Williams when I acquired, I meaning Mr. Friedman, the Willowwood LLC, and I'm going to try to resell it.
Correct. But it was used by ministry for a while and different individuals live there.
Okay.
That's no longer happening. And so he's attempting to sell the property right now.
Got it. And that's hard to do if it's occupied.
Hard to occupied, and you don't know who's occupying it or how they got in, and so yeah, it does create some difficulty.
Okay. So instead of seeking a dispossessory action, you think this fits the ejectment model because I guess it's the very first thing you said. You claim there's no lease.
Right, there's no landlord-tenant relationship.
Okay.
You got to have a landlord-tenant relationship for dispossession to be proper.
Okay. Have you had an opportunity to look at any of the exhibits that Ms. Lawson or Mr. Holloway provided?
Yes.
Okay, I need to pull them up on my screen. Give me 1 second.
And I don't know how relevant any of them are because, they were served with the affidavit. They didn't produce a counter affidavit at the time of service, and it should have been immediately ejected. Now, they filed something titled counter affidavit, but it's not notarized, so it doesn't count as an affidavit.
Well, maybe I'll give them a chance to notarize it, and then it would be a counter affidavit. But I'm interested in
it would be
your thoughts about, let me see if I can find. So Exhibit A that Mr. Holloway filed is a residential lease agreement. And so when you say there's no lease, there actually is a lease. It may be a complete forgery. I'm not vouching for it one way or the other, but there is a multi-page lease. Interestingly, it has Mr. Friedman's address, Lawrence, New York. And if we keep going, it's got a signature of Dolores Saunders, not saying it's hers, but there it is. So when you say no lease, what then are you calling Exhibit A from Mr. Holloway?
It's just something created and signed by someone that's not authorized. Dolores Sanders is not authorized to sign for 1012 Willowwood, and Mr. Freeman Sanders produced this lease.
So it's just a funny coincidence that the purported landlord is the same person that Mr. Friedman uses to check up on the property?
No, I mean, all this stuff is contained in the Secretary of State and the deed records. I mean, it's easy to find this information.
Dolores Saunders' name is in there?
No, all the mail that comes there may have had her name on it.
Okay. All right. Well, keep going. I didn't mean to interrupt you. You've helped me understand why you think that the ejectment process is the correct one and going to magistrate court would be the wrong one, because from your client's perspective, there's no landlord-tenant relationship. And it sounds like he could, under oath, say, and he's already, I don't know what was verified. I don't know these people. I did not authorize them to be there. How do we work through it if, I'm asking your legal answer here, if we dig a little deeper and Ms. Saunders maybe isn't doing the right thing by Mr. Friedman, was trying to make a little money on the side, thinking he wouldn't know because he's up in Lawrence, New York, and she's trying to rent it out on the side. And Ms. Lawson and Mr. Holloway have no way of knowing that she's not authorized. She's got a key, she has a parent authority, et cetera. How does that make Ms. Lawson and Mr. Holloway into intruders?
There's no landlord relationship between 1012 Willowwood and the defendants here. And Ms. Sanders lives in New York also. She hasn't been down here. And, you know, there's no evidence of any payment or anything. There's just a small receipt written, but, you know, there's no check, money order. It's just documents you just can, you know, produce anywhere.
Yeah.
You know, the handwriting is very odd,
It
you
is.
know, on the lease. And, you know, December spelled different ways, DCADECE. You know, it's just, it's just very strange.
Okay.
You know, this wasn't about payment of rent because they're intruders, but all of a sudden, you know, the CDC guidelines about eviction are attached to the documents. You know, and that's not really relevant because it's not about payment when you're dealing with an intruder. They're stranger to the property and stranger to title.
Okay. Okay. Yeah.
So here you have a situation where individuals just entered a house, changed the lock, created a bunch of documents and said, you know, we're leasing.
And you're saying the locks have been changed. In other words, if Mr. Friedman or Ms. Saunders showed up with the key they thought would unlock the front door, it doesn't work anymore.
Haven't been able to try it, honestly. Approached the house and a gentleman brandished a firearm. And at that point, we knew it's probably better to file the ejectment action.
This happened to you? Someone brandished a firearm at you?
To an employee of mine.
Okay. All right. I'm sorry to hear that. Okay. Well, I'm happy to hear from Ms. Lawson and Mr. Holloway in a moment. I'll come back to you, Mr. Roberts, in the end. Is there anything else you want to add, or it's pretty much as you spelled it out in your petition?
Pretty much how I spelled it out in the petition.
Okay. All right. So Ms. Lawson, I'm happy to hear from you. I'm happy to hear from Mr. Holloway. You don't represent Mr. Holloway, so it wouldn't be appropriate for you to speak on his behalf and vice versa. So I guess what I'd like to start with either one of you, and you two can decide who's going to start. Tell me what happened and where have you been paying rent? Because of course you shouldn't expect that you're able to live there for free.
Right. So initially, we responded to an ad to move in, and we met with a lady that gave us a tour, and she gave us she basically told us how much it was to live here, and the security deposit, and she had us fill out the application. She said she was going to do a credit check, and we passed. We paid her the security deposit plus like 3 months worth of rent, all in advance.
And when you paid this, did you pay in cash or did you write a check?
We paid in cash.
Who pays that much money in cash? Why did you not use a check so that there would be a paper trail in this situation?
Well, we figured the receipt would be enough. We just didn't. We were both coming half and half, so we just pulled, you know, our own cash together, and we just gave her cash up front.
Okay.
And she gave us a receipt.
And when you paid in cash, you said it was a deposit and first 3 months rent?
Yes, sir.
And what was the total amount?
It was like, I think like 4,600 total.
Okay. And what was the monthly rent supposed to be?
$1,150.
You mentioned that there was an ad that you saw to move in. This ad, do you have it?
I had it screenshot in my other phone, but that phone broke. I don't have that phone anymore, unfortunately.
Where did you see the ad?
Craigslist.
Do you remember the name of the woman you met with?
Dolores Saunders.
Can you describe Dolores Saunders?
She was probably about 5'5", 5'6", kind of chubby, maybe around my skin tone, probably slightly lighter. She looked like she had on a short wig at the time. She looked like she may have been either from the islands or African or something like that. She kind of.
Did she
like
have an accent?
Yeah, she did.
Okay. And what did she tell you her connection with the house was?
So she told me at the time that she was the owner.
All right. So you give her cash, you give her almost $5,000 in cash, and you're able to move in. What was the plan? How were you supposed to continue to pay rent? Because eventually you're going to get to month 4 and you're going to owe $1,150.
Right. She was supposed to be coming to collect the money. This is what she said. She was going to be coming once a month to collect the money, and she was going to do an inspection.
Why would she be doing an inspection?
Honestly, I don't know. It sounded weird, but I just went with it. We agreed to it in the lease that she could do it at any time. And that's just, I mean, at the same time, I didn't feel like I had anything to hide. If she just came, while she was collecting the rent, was like, hey, is it okay,
Sure.
to look over?
When is the last time you paid Dolores Saunders any rent?
The last time I saw her, which was back in, December? That was the last time I saw her.
So you've lived at 1012 Willowwood for 10 months rent-free?
Yeah. Once the person, Michelle Benson, came to the property, that's when everything got weird.
So why do you think you ought to be able to stay in the place if you haven't paid rent for 10 months? That's $12,000 you, per a contract you signed, you owe Ms. Saunders.
Well, the thing is, it's not that I wasn't willing to pay. Like I said, once Michelle Benson came into the picture, everything got weird. The number that I was provided by Dolores to contact her I was no longer able to contact her. Then somebody named Dolores Williams, who claimed to be different than this Dolores Williams, I don't know, started calling me, threatening me, threatening my family, saying she's spying on me. She sent her son to the home. That's the employee. He's was a little child. He had to been about 18 years old, according him and another guy came here one evening unannounced by foot, out of nowhere, claiming to be the son of Dolores Williams, saying Dolores Williams, and he said his name was Dexter Williams as well, and and he wants to know. He said his mom said, "When are you guys leaving?" It's just been a whole lot of stuff that's been going on, and it's just been kind of weird. We don't know who the true owner. We didn't know who to contact to even try to come to any kind of resolution. Nobody has tried to contact us. All we know is we've been served with this paperwork.
Okay. And you haven't paid rent in 10 months?
No, sir. But we have maintained the property. And just to add, the utilities were not on when we moved here. The house was not furnished. We was even told by our neighbor, who's a retired state trooper, this house was foreclosed several years ago, and all that furniture was sold by the HOA because nobody came to claim it. We moved in here, there was cobwebs, there were bugs. We had to pay a bug service fee to have the place sprayed down. That's how bad it was.
Okay. So all the furnishings that are in the house now are yours or Mr. Holloway's?
Yes, sir.
Okay, all right. Mr. Holloway, anything you want to add in response to the questions that I asked?
No, sir. She has it covered.
Okay.
Oh, may I add something?
Yes, ma'am.
I believe he said that Mr. Grady said something about we were claiming the title. Just to add, we're not claiming any part of the title.
Okay, I didn't hear Mr. Roberts say that, but that may be in some of the pleadings and I may not have picked up on that. But as I understand it, Ms. Lawson, you and Mr. Holloway view yourselves as tenants. You have leased it, you executed some document that is Exhibit A to Mr. Holloway's submission. You claim that's the lease that Ms. Saunders provided, and it has what you say is your signature and Mr. Holloway's, and then a real shaky signature of someone who wrote Dolores Saunders on there. Okay, I think I understand your side of it. The lease is up. If you had been paying rent and this had been a more normal scenario, and it sounds like there was very little that was normal about it, the lease ends in December, is that right?
Yes, sir.
Let me see, in fact, specifically. Yeah, so it ends December 1st. So about 2 months from now, and then it would continue month to month if not terminated. All right.
Okay, I'd like to bring something to your attention.
Please.
Okay, prior to the defendants moving here, they were living in another house where the owner, who had gone out of town, came home to find them there, and they filed a dispossession action, and the grounds are in home without permission of owner. And you can take judicial notice of that as filed before the county. It's 19 ED 135052. And they entered a consent order and agreed to get out around the end of December, and all of a sudden they show up at 1012 Willowwood under the same circumstances. So it's very, very bad luck or just a terrible coincidence, but they end up being in houses that are without permission of the owner. And everything's paid in cash, and the signatures on this document, this dispossession action, match the strange signatures in writing on the other documents.
Okay, well, I certainly can and will take judicial notice of official records of our courts. So I'm looking at 19 ED 135052, Betty Lindsay versus, look at that, Ms. Lawson and Mr. Holloway. Let's see what we've got here. So, wow, Ms. Holloway wrote a long letter.
No, we had an attorney at the time. May I say something?
Sure, while I'm reading your long letter that describes somewhat parallel situation. That's a remarkable coincidence.
That actually, we had an attorney with that situation. We were literally on a lease with the owner, Miss Lindsay, who at the time, she had a representative, what was his name? Jamil. I don't remember I don't remember the last name. Jamil, who actually he didn't want to honor the lease, and he got into Miss Lindsay's head, and out of nowhere, Miss Lindsay decided she didn't want us there, and that's why we had legal aid involved. It was a legal lease between us and Miss Lindsay. It was not a similar situation. Miss Lindsay was not also not out of town. Miss Lindsay had not been occupying the property since her husband had passed, which is why they had leased the property out in the first place, because it was
Okay.
just.
And so, and Ms. Linton has committed a crime because under oath, she stated in the home without permission of owner.
She did commit a crime, and we did bring that up when we went to mediation. Because she didn't want to go, we decided they didn't want to honor the lease. They didn't want to fix any of the things that they agreed to fix, because there was a lot of things that needed to be fixed within the home. There was code enforcements that were being broke. I believe that they had a lawsuit for that. It was a lot of things going on. So yeah, she did commit a crime.
So Jamil Dade is this person you're giving cash to. It is a remarkable coincidence, Ms. Lawson and Mr. Holloway, that you bounce from one scenario that's got some strange clouds over it and cash and not paying with check and this and that, and then the police getting involved. Then we fast forward. We don't even have to fast forward. I mean, it happened right after this, another strange situation. I mean, you must feel real unlucky. Maybe you should go to like an apartment complex where everyone knows it's a real lease, because they will not take cash. You have to pay in check. I think you'd be tired of having this happening if you had nothing to do with it.
I am very tired. And again, the situation with Miss Lindsay was completely different than this situation. That was really more so Jamil Dade was the drive behind that force. Miss Lindsay, again, she was very up in age. And Jamil Dade was the one calling all the shots. He refused to take cash. At one point, he refused to even give us a receipt until we had to call Miss Lindsay. It was a lot of things going on. It was a lot of back and forth. I think, I'm sorry, not refused to take cash, but he refused to take anything other than cash. That was a crazy situation, but we were there legally with Miss Lindsay and her agent, Mr. Dade. And I believe the same thing. I believe we're here legally as well. It is crazy. Yeah, it is crazy. And yeah, I am tired of it.
Okay.
It is.
Well, the way the Lindsay matter resolved is that it sounds like maybe this was the product of the mediation, but the consent agreement that Judge Rickman signed in the end had you, Ms. Lawson, and Mr. Holloway vacating by October 30th, and you dismissed your counterclaims, and people walked away from the situation. You did not owe Ms. Lindsay any more money, and Ms. Lindsay agreed not to tell a credit agency that you were delinquent in any way. And there you go. That's how it resolved. Why should this not resolve in the same way? With one caveat, it sure seems like you and Mr. Holloway owe Mr. Friedman a bunch of money because you've been in his house now for 10 months without paying rent. And I'm not saying you didn't try. I don't need to get in the middle of that because it sounds like Mr. Friedman didn't know you all were there. Crediting your version for a moment, Ms. Lawson and Mr. Holloway, you got duped by whoever this person claiming to be Dolores Saunders really was. But after December, you've lived there without paying rent. And so if you were to get out real soon, and we could talk about what a reasonable time frame is, it would necessarily involve some payment, and it can go into the registry of the court, and then I can make sure that it goes to the right place. For these months of rent-free occupation. In other words, it's not a fair outcome to say whether you were to leave at the end of the lease, and I hear Mr. Roberts saying that it ain't a lease that his client ever signed, or if you were to leave sooner than that, which seems like the right answer here as I weigh the equities, there need to be some payment made to cover the fact that you and Mr. Holloway have been there for these months, maybe trying to pay rent, but in the end, not able to because there wasn't someone to hand it to because apparently people didn't want checks again.
Okay, well, here's the thing. During that whole time, like I've been stating and I have submitted, we were being harassed the whole entire time. People were coming to the house unannounced. People were threatening us. We were getting phone calls. Our utilities were cut off.
So this is sounding a whole lot like Ms. Lindsay's situation that you told me was completely different. I just read your 3-page letter in that case, and you were being harassed, and this Jamil Dade guy was harassing you, and it was trouble, and things were getting cut off. This is sounding like an echo chamber now, and you're telling me it was completely different.
Well, we know for a fact that Jamil and Ms. Lindsay were in cahoots because we actually met Ms. Lindsay. We actually sat and talked with Ms. Lindsay. Ms. Lindsay had actually been to the home, and she had actually told us that they were going to pay the utilities themselves. It was actually included in our lease. So all of that was them. This situation, utilities were actually in my name. Mm-hmm. It's not included in the lease. They actually called and had my utilities cut off to a point where I couldn't even restart one of my services again. And I had to go to a whole nother company. And these people, now they're claiming, I don't know, I never met Mr. Freeman. So I didn't even know that he existed. I didn't know anything about him. All I knew was Dolores. I didn't know Michelle until Michelle popped up claiming to work for Dolores Sanders. And I didn't know who Dexter was until the utilities got cut off or until a bill came from State Farm here in Mr. Williams' name. I didn't know who any of these people were. So at this point, it was really just all in the word of what I was being told by Dolores. And with Miss Lindsay and Jamil, I knew for a fact that was Miss Lindsay and that was Jamil.
Okay, so you were more familiar with the folks who were doing the kinds of things that seem real similar to what people have been doing in this situation. You just were less familiar with Ms. Benton and Dexter Williams Jr., et cetera. Ms. Lawson, are you employed? And if so, what do you do?
Yes, I'm a consultant. I do I consult with credit and I also consult with music as well. So
are you like 1099? Someone hires you, or do you work for a company that does this?
Yeah, I'm 1099.
Okay. Mr. Holloway, are you employed? And if so, what do you do?
I'm a club promoter, so 1099 as well.
Okay, thank you. All right. Mr. Roberts, anything more you want to add?
Yes, in reference to the lease, it says, they're going to pay a security deposit of $1150. I don't know if they produced a receipt for that. And then right below that, it says the money will be placed in such and such account with such account number. That's just scratched out. It's not there. I mean, that's just very, very, very suspicious to me. And in terms of that previous case, I spoke with Miss Lindsay, one paralegal did, and she had to end up paying. She went to Egypt for 30 days, came back.
She went to Egypt?
Right, for 30 days with her granddaughter. She comes back and someone's living in the house with all her stuff, and she ends up paying $10,000 to convince them to move. Next thing we know, they show back up at 1012 Willowwood with some suspicious person with an accent that, no one knows.
$10,000 to who?
So, hey, this is not a conversation between Ms. Lawson and Mr. Roberts. Mr. Roberts is sharing his perspective, and I also listened to your perspective on this, Ms. Lawson, and I appreciate both sides of this one. This is it is a strange set of circumstances. We certainly need to resolve it. All right, Mr. Roberts, anything more you want to add on behalf of 1012 Willowwood?
I don't believe so, Your Honor.
So Ms. Lawson and Mr. Holloway, I don't want you all to be surprised by how this is going to play out. I'll tell you what I'm planning to do, but I don't have specifics in my mind yet. I need to think about it some. I'm planning on requiring you all to get out before the lease is up, but I want to give you some time to leave in an orderly fashion. You will get more time to leave in an orderly fashion the more you are able to put in the registry of the court to cover the back rent, the rent that was not paid from January through now. I'm going to work through some of those figures in my head, but the order that I enter will be something along those lines. If you have any thoughts about what is a fair amount of time to give you and what is a fair dollar amount, I'm happy to hear from you on that.
Gosh, we're being put on the spot here.
Well, and I'll tell you what, I don't mean to put you on the spot. If you and Mr. Holloway want to talk through this, you could certainly email me. Have you received emails from Ms. Niles, my staff attorney?
I did yesterday.
Okay, so point being, there is an email connection between you and Ms. Niles. We certainly know how to reach Mr. Roberts. And so what I'd ask you to do is by 5 p.m. today, send an email to Ms. Niles and you need to copy Mr. Roberts. If you don't have his email address, we'll make sure he sees what you send us. But ideally, anything you communicate to Ms. Niles, Mr. Roberts needs to see as well. And just know anything you send Ms. Niles, we'll share with Mr. Roberts if you don't share it with him, and vice versa. It's just both sides need to know what's being communicated to the court. But you and Mr. Holloway confer and let me know what you think is a reasonable amount of time to have to get your stuff out of 1012 Willowwood, and what you think is a reasonable amount that you could put in the registry of the court that would get you that reasonable amount of time. Because again, if you say we're not going to pay anything, then I'm probably going to accelerate the timeline to get you out of there, because what would follow behind it would be the ejectment thing. And I just assume that not be how it works, because that's messy and it's embarrassing and that's not what this needs to be about. But I think it is fair to say that this lease needs to end early. It hasn't gone the way it was supposed to. I'm not putting that at your feet, Ms. Lawson, or your feet, Mr. Holloway, but I think we can all agree that it has not gone the way it was supposed to. And it may be because of the harassment. It may be because there was some funny business with a fake Ms. Saunders. It may be because here you are finding yourself in the same situation again, which is also a little surprising to me. I don't need to work through that. I would just as soon have folks live as happily ever after as possible. But there's clearly going to be a disruption because you're not going to be in that place through the end of December of this year. So you and Mr. Holloway think through what is most reasonable, share that with Ms. Niles and Mr. Roberts, and that will inform the deadlines and the dollar amounts that I put into the order that addresses the petition that's been brought to me.
May I ask a question, please?
Yes, ma'am.
How does the CDC moratorium doesn't apply to us when it says residents of when it says tenants of residence?
So,
And the whole country hasn't been paying rent since COVID. So how does it not apply to us?
well, I'm not your lawyer, so I'm not going to give you legal advice. I'll make a few observations. The CDC is not the court's boss. That's guidance, but the CDC does not have authority over any court in the United States of America. 2, you have never told me that you were unable to pay rent. You have told me that you didn't know where to send it because Ms. Saunders' phone got cut off. And I understood you to be saying we would have paid $11.50 each month, but things went down the drain real quickly. All of a sudden they're turning our utilities off and this is happening and that. But I didn't hear you say once, you know what? We tried to work with Ms. Saunders and said, you know what, this month, could we pay $500? Could we defer rent payments? It's not what you were telling me. And that doesn't seem to have been the storyline with Ms. Lindsay either. Was we were harassed and people were doing things to us. Not that you couldn't afford it. As I understand it, you're a consultant. Mr. Holloway is a club promoter. You were able to afford furnishings in an unfurnished house, establish utilities, which requires a credit check, and you were fine paying those utilities until someone intervened and took some of those utilities out of your name. So this is not an eviction for let me just finish, because you asked the question. What the CDC's guidance indicates is that it's not a good idea to evict, which is not what this process is, for non-payment of rent because someone cannot afford the rent. And there's nothing in any of your pleadings that suggested that the hangup was you couldn't afford rent. And you just told me, and I assume I should believe you, that rent wasn't the issue. You didn't know who to give it to. It was a little weird that it was in cash, but apparently that's how you've rolled your last two residences, Ms. Lindsay's and this one. So what the CDC is talking about is a scenario where the tenant, so there's got to be a valid lease, says, because of COVID, I have no money, I cannot pay. And the CDC has said, it's not going to help public health if you evict those folks. Mr. Roberts is not seeking eviction, he's seeking ejectment. And you may say, what's the difference? You're taking me out of my place, and I hear you on that. But there's nothing in his pleading that says this is about rent. In fact, he hasn't asked for any money. I'm the one who has brought that into the mix. And if I were to find in favor of 1012 Willowwood, the ejectment could be immediate. The sheriff could show up tomorrow. I don't think that's fair. I don't think that Mr. Friedman is going to suffer a whole lot if you are there a little bit longer so that you can arrange an orderly departure. Mr. Roberts is going to say, that's not what the law says. And you can say that, and he'll be frustrated with me again. It's happened before. But if you want a gentle glide path out of there, you're going to need to recompense Mr. Friedman for the fact that you've been in his house for almost a year and haven't paid for it. That's not unreasonable either. So I'm just trying to make this reasonable as possible for everyone. There are parts of this that are completely unreasonable for Mr. Friedman. There are parts of this that are completely unreasonable for Ms. Lawson and Mr. Holloway. That's what makes this a weird one. That was a very long answer, but I wanted to explain myself because you asked an interesting question. But I'll end how I started. The CDC is not the court's boss. Anything else?
Anything you want to say? I wasn't about to say anything. You have anything you want to say? He heard me when I said that. He heard me when I said it was before COVID.
I don't have any other questions.
Okay. So Ms. Lawson, we will look for an email from you or Mr. Holloway about your thoughts about how to wrap this up. Get that to Ms. Niles by 5 o'clock today. And if I don't hear from you, I'm gonna have to wing it on my own, not knowing how complicated it would be for you to move out and not knowing your financial situation. So input would be helpful. And then I will take it from there. Mr. Roberts has said what he wants to say. Anything else you want to add in closing, Ms. Lawson or Mr. Holloway?
I will say this. You are absolutely correct. I did not make it imply as though I would be having problems to pay the rent because everything was happening before COVID did hit. As Mr. Holloway was saying, everything did happen before the COVID hit. I can't, obviously, for Mr. Holloway, clubs have been shut down. So obviously things aren't working. And for me, as someone that does, part of my consulting, I deal with a lot of music artists, things have shut down. At this point, I am receiving unemployment. So yes, I do have a hardship. So had maybe I was able to reach somebody, they would have known that and we would have tried to make those. But if I can't even reach anybody, I can't even do that much.
Okay. Well, I hear you on that. And that's why I said there's a lot of this that is remarkable, and query why it took 10 months for this action to be filed. If Mr. Friedman had known 9 months ago that there were folks who were not supposed to be in his house there, steps could have been taken actually pre-COVID. But here we are. I'm not faulting anyone for the action being brought when it is. It's brought when it is, and it's a very complicated time for folks. Ms. Lawson, that will, it sounds like, affect what you share with Ms. Niles about your ability and Mr. Holloway's ability to make any payments. But surely it must have crossed your mind and Mr. Holloway's mind at some point in the last 10 months. This is remarkable. We are in a nice big house, 4 bedrooms, 4.5 baths, in a nice neighborhood, and we are not paying a nickel for it. If you tell me that never crossed your mind, there goes your credibility. At some point, this was going to catch up with you, and maybe you have a rainy day fund for it, maybe you don't. But folks don't get to stay in a place like that and not pay for it. That's life. You're going to let me know if you're able to put any money into the registry or not. And I hear you now loud and clear, a little late in the process to bring it up, that you're getting unemployment and Mr. Holloway is finding that being a club promoter in these times is complicated. I get that. It makes sense. This isn't a great time for folks to go clubbing. And so these must be leaner times for you all. Please get that email to Ms. Niles by 5 o'clock today, and I will take this from here. All right?
Okay, thank you.
All right. Thank you, everyone.
All right, thanks.